Okay, so welcome everybody. This is the very first CCLS, this is the Centre for Commercial Law Studies here at Queen Mary, University of London. It's our very first roundtable in animal law, and we're absolutely delighted to be welcoming Ankita Shanker here to present her research. My name is Johanna Gibson. I am Herschel Smith Professor of Intellectual Property here at Queen Mary, but I'm also the convener of animal law here at Queen Mary in the postgraduate program, so in the LLM program. I'm just going to take you through a little bit about why I see animal law as being very critical in such a setting as in a commercial law center and in postgraduate commercial law studies. And I see it as a really important innovation, not only in the curriculum, but also in the quality of transcript and the quality of education that students are leaving with. I'm always very proud of the students that do take the animal law modules, because I see that they have a real, that they are embracing that innovation on their transcript. They're showing that imagination, and they're leaving Queen Mary with that kind of diversity on their transcript that I think really sets them apart. So, and I'm always very delighted. We always have a wonderful discussion as well in the modules. So in terms of having animal law in a commercial law program, it's very important to think about it not as a niche area on its own, but actually how animals, excuse me, how animals and their interaction with the law interacts with a whole range of legal disciplines and a whole range of areas in which people might be specializing. And it's almost artificial and contrived to keep animals outside that discussion and outside that education. So everything from environment and climate change to science and regulation, media and culture, authorship and performance, and fashion, equality law also, intellectual property and innovation, and similarly social media. Social media is a teaching social media and looking at the treatment of animals in social media is a very important topic. So the law needs its cage rattled, and I think people's approach to how we study law, how we teach law, and how we practice law is part of that revolution, if you like. I hope that's not overstating it. And that's because a lot of law is not only researched, but also taught in a way that is obviously distinctly anthropocentric. Even just in reactions to the recent episode in the UK regarding a footballer and their cat, led to some really sometimes quite surprising discussions in social media, which were always just went back to the default, it's just a cat. And so it's not only about animals in the law, but it's also about animals on the law. And what I mean by that is actually approaching the law from a perspective, from a multi-species perspective. So drawing upon science and behavior to examine the law from a non-human standpoint. And that is certainly how I teach it in my modules. So animal law at the Centre for Commercial Law Studies. When I introduced the first animal law module in 2018, it meant that the Centre for, here at CCLS, it meant that Queen Mary became one of the very first law schools in the UK to include animal law as a formal part, a credit-bearing part of the LLM program. So not just an aside, not just something that people could do as an optional extra, it's actually a core module on the commercial and corporate, international business law and IP&T and technology programs. Now, this is actually very significant, I think. The LLM program at Queen Mary is one of the largest in the world. There's 25 specialist streams, and the current cohort is over 1,000 students. There's 850 from that are international, and the students come from, at the moment, more than 150 countries around the world are studying the LLM this year. So it's genuinely international, and it's interdisciplinary research, and there is an interdisciplinary scholarship. And by that I mean not only interdisciplinary with disciplines outside law, but also within the law. So looking at the interaction between animal law and intellectual property, or social media regulation, or trade. The other thing is that it's research-led teaching. And that means that part of that is also innovative curriculum development. And I think that's something that we're very proud of at Queen Mary. And so it's wonderful to have Ankita here to kind of celebrate this with us today. And when it comes to the animal law modules, so we now have 2 animal law modules. We have animal law, welfare and trade, which deals with science and regulation, technology, innovation, and intellectual property, looking at intellectual property also as a kind of ethical tool, as a way to improve circumstances. So looking at alternative proteins, looking at non-animal technologies and so forth. We also look at wildlife trade and wildlife crime, and in conjunction with that, the concepts like wild animal suffering and welfare biology, and of course, wild farmed animal welfare. And then in the other module, which is animal law, media and culture, it's a really fascinating module to teach and also to share with the students. We look at non-human creativity and sentience and personhood, and consider that in the context of theories of authorship and performance in human authorship and performance as well. We look at animals as they appear across a range of creative industries. So we consider film, television and advertising, social media, regulation and offences, fashion and art, and copyright and morality, and whether there is an important role within intellectual property and within the structure of intellectual property to address some of the uses of animals in these creative industries through morality provisions. And as you can see, it's welcomed in the mainstream program. Animal law, welfare and trade is accredited on the general LLM, on the commercial and corporate LLM, the international business law LLM, and the intellectual property LLM. And animal law, media and culture is accredited also on technology, media and telecommunications, because we deal quite a lot with social media regulation as well as media law more widely. So we also have a growing PhD community in animal law, and they are almost all here today, because one is just starting. And some of the current projects working in wildlife and rights jurisprudence, dog breeding, history, culture, regulation and reform, and also the exotic pet trade and platform liability and regulation. So you can see very clearly the interaction with other areas of law and there, of course, with technology and social media regulation and so on. And the wider animal law research community at CCLS. So we really stress in everything we do that this interdisciplinarity, including between different legal disciplines. But we're also very conscious of providing a forum for postgraduate and early career researchers to present research, as well as established scholars, which is why I'm particularly excited to welcome Ankita, who is embarking on, well, is progressing with her PhD, I should say. And so having that opportunity to give her a platform as part of the development of animal law more widely, I think is also very important. And I'm really excited to hear her paper today. We also have a visiting scholars program for established scholars and visiting research student scheme for PhD researchers, so that you can come and visit CCLS for a while and use the resources. We can plan events and so on and so forth, which is really part of that extended research community in animal law as well. So it's a genuinely international research community. And of course, if you want to find out more about it, you can contact me on my email. So I'm going to hand over to Ankita. I'm very pleased to welcome her here. She earned her postgraduate degree in law from Oxford University, and she qualified as a barrister at the Bar of England and Wales. She's been in legal practice at international criminal courts and tribunals, and as you know, she's now working on her PhD, specifically in animal rights law and policy. She's funded by the Finnish National Agency for Education and the Swiss National Science Foundation at the University of Basel. What's also very exciting about Ankita's work is that she does a lot of work pro bono and with the wider animal law community and developing legal practice and so forth. And so she's a mood coordinator at the UK Centre for Animal Law. She's a consultant She's worked as a consultant composing law and policy recommendations for the EU on behalf of the Dutch Coalition for Animal NGOs. And she's also been a legal and policy advisor to various animal NGOs in this capacity. And a very important role that she's also, and a very important achievement, and something that shows the interaction between non-human animal rights and human rights also, and how she's been able to develop this area of jurisprudence, is that she was appointed by the International Commission of Jurists as a moot court training expert to Myanmar, and she set up and ran the first international human and animal rights law moot court competition. So it's a wonderful achievement, and I'm very, very pleased to welcome Ankita to talk about recognizing and protecting personhood and fundamental rights for non-human animals. So thank you, Ankita. I will hand over to you.
Thank you, Professor Gibson, for that wonderful introduction and for putting this event together. And thank you to everyone who's here for being here. It's really great to see all of you. So before explaining why animals are already fundamental rights holding persons, I will provide a brief introduction of my PhD project. I start with the notion that under international and most domestic legal systems, all human beings are entitled to formal recognition through declarations and legal protection through binding laws of their legal personhood and fundamental legal rights. Now, whether this translates into practice is a different matter and beyond the scope of my research. Today, this equal entitlement of all humans to personhood and fundamental rights is not only unquestionable, but even the prospect of questioning it unthinkable. This is the case in both legal and societal discourse. This universal status for humans is the result of a gradual process of expanding recognition and protection of personhood and fundamental rights. So what started out to cover only a small group of humans has now expanded to cover us all, thankfully. I argue that this process should conceptually continue until all fundamental rights holding persons are included within the scope of such recognition and protection. Thus far, however, this does not appear to have happened, because despite the universal scientific and widespread legal consensus on the sentience of many non-human animal species, animals are still excluded from the scope of personhood and fundamental rights. What this means is that they are legally held captive, exploited, abused, and killed on massive scales in nearly all jurisdictions, even for trivial human purposes such as entertainment or fashion. In fact, animals are not even protected against treatment that resembles certain historic forms of human exploitation, such as enslavement and torture. Enslavement and certain contexts of torture are now prohibited also by jus cogens or peremptory norms of international law. As such, derogations from these prohibitions is never permissible in the case of humans. Humans thus rob animals of their freedom and their way of life, dehumanizing them through cruelty and forcing them to live in servitude. My research posits that animals hold personhood and fundamental rights under the foundational principles properly understood on which positive international as well as most domestic fundamental rights law is based. However, this position is not currently reflected in the law's provisions or practice. This is based on the premise that positive law has two dimensions: foundational principles and provisions. Because the provisions do not necessarily reflect the foundational principles that are supposed to underlie them, a disconnect is created in such cases between the provisions and principles. In essence, I argue that positive law must be interpreted in line with its underlying foundational principles, and its provisions must be changed to reflect that interpretation. The aim of my thesis is to demonstrate how law should make its current position visible in its provisions. In an era defined by global efforts on an unprecedented scale to safeguard fundamental rights, the apparent lacunae in legal frameworks caused by the exclusion of animals demands investigation. Likewise, any apparent internal inconsistencies within the law between its principles and provisions must also be examined. If it is found that there is no relevant principled distinction between humans and at least some other animals, there can be no principled basis for formally recognizing and legally protecting the personhood and fundamental rights of the former, while denying the same treatment to the latter. In such a situation, there can thus also be no convincing principled basis for the existing legal status of these animals vis-a-vis humans. Moreover, if there's a discrepancy between the holders under foundational principles of personhood and fundamental rights on one hand, and the beneficiaries under legal provisions of personhood and fundamental rights recognition and protection on the other, there would also be a disconnect between the provisions of positive law and the underlying principles on which it is based and which it purports to uphold and protect. Since the law requires like cases to be treated alike and justice demands to be done regardless of consequences, the rights of like non-humans cannot be ignored the way they currently are. So my research seeks to foremost identify the entire class of fundamental rights holding persons entitled to recognition and protection of their personhood and fundamental rights. It then contrasts this with the class of recognized fundamental rights holding persons who currently have such recognition and protection in place. The aim is to find whether any discrimination or discrepancy exists. And if this is found, my research will seek to prescribe changes to laws and legal systems to help remedy the situation. It will also consider the implications of such changes for the manner in which fundamental rights are currently exercised by recognized rights holding persons, that is, humans. In the 2014 Indian case of Ramesh Sharma against state of Himachal Pradesh, Justice Rajiv Sharma said the following: "The animals have basic rights and we have to recognize and protect them." The Himachal Pradesh High Court thus distinguished the having of rights from their recognition and protection. This case concerned an ostensible clash between the alleged human right to religion and the animal right against unnecessary pain and suffering. The court decided in favor of the animals, making various pro-animal declarations in the process. Rights holding persons. Now back to our main topic. Why animals are fundamental rights holding persons? The argument I make in my PhD, and the one I will be explaining today, is not that animals should hold fundamental rights, but that they already do. And I don't mean under moral or natural law either, but under positive laws themselves. In order to contrast the provisions of fundamental rights law with its foundational principles, with a view to identifying and correcting internal inconsistencies between them, three preliminary issues arise. The first is identifying the class of fundamental rights holding persons. The second is determining the content, strength, and limits of fundamental rights of beneficiaries. And the third is determining the content of the personhood of beneficiaries. Today, I will be focusing on the first of these issues by looking to positive fundamental rights law's foundational principles. I do this in order to identify the class of fundamental rights holding persons who, for internal consistency, should be encompassed by its provisions. Thus, this part of my research aims to identify both the class of those who are legal persons as well as the class of those who hold fundamental rights. In this exercise, the starting point is to ascertain the basic position under fundamental rights law as to who is a fundamental rights holding person. This is relevant because these foundational principles determine the class of beneficiaries who should be covered by positive legal provisions. That is, those who are entitled to recognition and protection of their fundamental rights and personhood. However, these foundational principles cannot be discerned in isolation of other relevant considerations, such as the rule of law and justice. These latter considerations must be superimposed into this exercise in order to properly understand the foundational principles of fundamental rights law. This is because the rule of law and justice are overarching notions in international and most domestic legal systems that must be considered when determining issues of things like fundamental rights law. So reference must also be made to the predominant foundational principles of the rule of law and of justice. This in turn determines who is a fundamental rights holding person entitled to recognition and protection of their fundamental rights and their personhood. Thus, in this exercise, the basic position under fundamental rights law is first considered, and then the overarching considerations from the foundational principles of the rule of law and justice are added to the endeavor. Using Ronald Dworkin's Interpretivist Framework, this can be done in 3 stages. First, the pre-interpretive stage involves identifying the rules and standards that provide the tentative content of the practice. For our purposes, this would be identifying the sources of fundamental rights law, of the rule of law, and of justice. The second, or interpretive stage, entails discerning the general justification for the main elements of the practice. And in our context, this means identifying the foundational principles of these laws based on their respective sources by determining their justification. Lastly, the post-interpretive or reforming stage involves adjusting what the practice really requires so as to better serve the justification accepted at the interpretive stage. And in our context, this would entail refining the class of beneficiaries of personhood and fundamental rights required to be reflected in the provisions based on the foundational principles of the laws identified in the second stage. Basic foundational principles of fundamental rights law: universality, equality, and inalienability of rights. The first step is discerning the basic foundational principles of fundamental rights law relevant to identifying the class of fundamental rights holding persons. In this context, international and most domestic legal systems are largely built on the foundational principles that all humans are persons with universal and inalienable fundamental rights to which they are entitled to equal protection. This position can be discerned from the text and travaux preparatoires of various fundamental rights law instruments, from customary international law, from the general principles of law as discerned from domestic laws, from case law, as well as from the writings of legal scholars and jurists. It is evident from these various sources cited that all humans are entitled to fundamental rights and personhood in accordance with these foundational principles. This fact is reflected in the provisions of fundamental rights law as well, such as the Universal Declaration of Human Rights or the International Covenants on Civil, Political, Socioeconomic, and Cultural Rights. Thus, in the context of human rights, their universality means that they are possessed by all humans. Their inalienability means that they cannot be taken away from or renounced by any human, and their equality means that all humans are entitled to rights on an equal basis. Going back to Dworkin's interpretivist terminology, the inclusion of humans as beneficiaries of fundamental rights and personhood would be treated as a paradigm in the interpretation of fundamental rights law. I, of course, do not challenge this position. However, that is not to say that this class of beneficiaries ends at humans. The next step is to consider the foundational principles of the rule of law and justice to ascertain the entire class of beneficiaries of fundamental rights and personhood, and determine specifically whether this class is limited to humans or whether it extends also to non-human animals, and if so, on what basis. Overarching foundational principles of the rule of law and justice, treating like alike. The overarching foundational principles of the rule of law and justice relevant to identifying the class of fundamental rights holding persons can be discerned primarily from case law and the writings of legal scholars and jurists. According to the United Nations, the rule of law exists where the law complies with fundamental rights norms and standards and reigns supreme such that no one is above it. In the context of the overarching foundational principles of the rule of law relating to fundamental rights, there is, among other things, an inherent requirement for the law to avoid arbitrariness. Now, international and most domestic legal orders are committed to the rule of law, and no legal system based on the rule of law can operate in the absence of avoiding arbitrariness. This is also an intuitive result of the law reigning supreme and complying with fundamental rights, norms, and standards. Thus, a relevant foundational principle of the rule of law, which can be found widely in the literature in the context of fundamental rights, is the maxim of treating like cases alike. Not only is treating like alike a consideration of the rule of law, but it is also a requirement under justice. According to Tammy L. Bryant, advocates of what she terms the similarity argument base their claim on animals' cognitive capacity and/or their capacity to suffer. Their argument essentially is that justice requires the protection of animals from human use and abuse on the basis that animals' similarity to humans is sufficient to warrant protecting animals in a way similar to humans. Thus, like the rule of law, justice also requires like to be treated alike, and failure to do so results in both a violation of the rule of law and in injustice. Since the rule of law and justice are overarching considerations in international as well as most domestic legal systems, the requirements under the foundational principles of both are superimposed onto the interpretation of the foundational principles of fundamental rights law under these systems. For positive law to comply with the foundational principle of treating like alike, if humans are fundamental rights holding persons, then other like non-humans also enjoy this status. The proper understanding of foundational principles of fundamental rights law means in light of the overarching foundational principles of the rule of law and justice. Since animals enjoy this status, they should thus also be encompassed by legal provisions of fundamental rights law. Using Dworkin's interpretivist framework again, during the interpretive stage, treating like alike emerges as a justification for the main elements of fundamental rights law, the rule of law, and justice, which in the post-interpretive stage would entail conferring on like animals similar recognitions and protections for their personhood and fundamental rights. So, the provisions of fundamental rights law today recognize and protect the fundamental rights and personhood of all humans on a universal, equal, and inalienable basis. Under positive law's actual provisions, the beneficiaries of such are currently limited to the class of humans. But if there indeed exist other like non-humans, they should also be included within the ambit of such recognition and protection. Thus, if certain animals are considered to be like humans, they would also be entitled to like recognition and protection of their fundamental rights and personhood. And failure to afford this like treatment results in internal inconsistency between the foundational principles and provisions of positive fundamental rights law. In the 2020 Pakistani case of Islamabad Wildlife Management Board against Metropolitan Corporation Islamabad, Chief Justice Athar Minallah made the following proclamation. Life, therefore, is the premise of the existence of a right. An object or thing without life has no right. A living being, on the other hand, has rights because of the gift of life. An animal undoubtedly is a sentient being. It has emotions and can feel pain or joy. Like humans, animals also have natural rights which ought to be recognized. Humans cannot aggregate to themselves a right or prerogative of enslaving or subjugating an animal because the latter has been born for some specific purpose. This case concerned granting freedom to the captive elephant Kaban. The Islamabad High Court found in favor of Kaban, holding him to be a rights-holding person and ordering his relocation to a more suitable environment. Refuting, ignoring likeness, lack of competence, and speciesism. Combining the requirements of the rule of law, fundamental rights law, and justice, like non-humans hold universal, equal, and inalienable fundamental rights to the recognition and protection of which they are entitled. They should thus be recognized and protected regardless of the consequences of doing so. So to deprive such animals of recognition and protection of their rights and personhood, the law must rely either on lack of competence to refute likeness or speciesism to ignore likeness. While using differences in competence speaks to refuting likeness, using a difference in species is not based in any relevant factual difference. It is just a distinction without a difference, and so is treated as ignoring likeness rather than refuting it. Refuting likeness through lack of competence. Arguments from human exceptionalism. To assess arguments against the competence and likeness of animals, arguments from human exceptionalism alleging the exclusive suitability of humans for personhood and fundamental rights are considered. These are based on humans allegedly possessing inherent value, exceptional capacities, moral agency, and/or legal duty bearing. Each of these can be rejected due to lack of universality and/or exclusivity to humans, suggesting that the rationale for the standard of competence and likeness lies elsewhere. The argument for inherent autonomous value or exceptional capacities of humans relies on the possession of attributes such as the possession of souls, the creation in God's image, abstract reasoning, self-awareness, rational agency, adopted primarily from the Kantian view, free will to make choices, personal autonomy, purposeful action, etc. The first point to address would be the alleged possession of souls, the creation in God's image, or abstract reasoning regarding God by humans and the alleged lack of such in animals. This position is impossible to disprove because such questions are not amenable to proof in the first place. It is for this reason that it warrants no further discussion. As to the rest, even assuming these features were exclusive to humans, the fundamental principles of fundamental rights law militate against the exclusion of sentient beings from legal protection just because they lack certain higher capacities. Reasons to exclude animals in this way are often based on arguments that can also apply to humans who will never be moral agents or legal duty bearers or engage in functions characteristic of the special capacities that purportedly make humans uniquely suited for personhood or fundamental rights. Here, I give the example of terminally ill infants and cognitively disabled adults. The argument from marginal cases demonstrates that there are no morally relevant capacities that are universally present in humans, while being universally absent in animals. Moreover, while animals may lack certain capacities that humans have, they also possess other capacities that humans lack. Even though such persons cannot, for example, bear legal duties, this does not prevent them from holding legal rights. Counter arguments to this rely on including marginal cases of humans within paradigm cases, but attempts to do this use reasoning to exclude all who are not human, and they're clearly fraught with speciesism. The argument is essentially that personhood and/or fundamental rights is or are limited to humans simply because they are human. So, since the law does not deny fundamental rights or personhood to humans with undeveloped or diminished capacities, it cannot deny them to animals solely on this basis without relying on speciesism, which I will address subsequently. Thus, as far as individual species members are concerned, arguments from human exceptionalism fail at justifying the status of animals specific humans. Even from a species perspective, however, these exceptional capacities are not exclusive to and/or not universal among human beings. With reference to observable and scientifically established facts about animal species vis-a-vis humans, it is evident that the notion of differences in capacities does not aid in refuting competence for personhood and fundamental rights of animals. In fact, available scientific evidence precludes any conclusion on a general lack of higher capacities in animals. Certain species have highly developed cognition and emotion comparable to humans, or at the very least human adolescents. In fact, there is compelling and converging evidence to the contrary that they lack capacities, higher capacities. Members of such species have been found to have metacognition, memory, imagination, reason, linguistics, numeracy, self-awareness, self-consciousness, self-knowingness, self-agency, autonomy, and a theory of mind. They have been known to understand abstract concepts and causation, to recognize themselves in mirrors, to imagine, imitate, and emulate, and experience and understand each other's experiences, to develop unique personalities and have desires and aspirations, to think about the past and future, make future plans, and pass cultural knowledge on to future generations, to feel and express intense emotions, including empathy and fatal bereavement, and maintain meaningful, lifelong personal relationships, to have a sense of fairness and justice, to engage in social play and games, to practice deception and anti-predator behavior and engage in hunting and wars, to function in complex social orders with power relations, hierarchies, moral and ethical codes, including respect and social homeostasis and respect for each other's possessions, to referentially and intentionally communicate in complex languages complete with regional dialects and accents, to engage in symbolic, social, and material cultural expression and rituals, including funeral rites that are suggestive of underlying theological belief systems, to build and use tools and build and manipulate structures, to self-medicate, and to generally live rich, complex, and fulfilling intellectual, social, cultural, and emotional lives with cooperation and competitiveness. Additionally, members of certain animal species also undertake and fulfill duties and responsibilities even voluntarily. The voluntary undertaking of duties and responsibilities is not limited to exclusively animal communities, but has also been observed in human animal communities. Thus, it absolutely cannot be said that humans exclusively possess the exceptional capacities that are frequently used to attempt to justify our special status as fundamental rights holding persons. However, two concessions do need to be made. First, at the species level, while animals may possess higher capacities, these are not equivalent to those possessed by humans generally. For one, animal capacities tend to be less developed than those of humans. However, for most capacities, the difference is not qualitative, but merely a difference in degree. For the rest, while there may be certain capacities that humans possess and animals do not, there is nothing to suggest that these capacities have any bearing on the latter's competence for fundamental rights holding or personhood. This is especially the case because non-humans also have a variety of capacities that humans lack, without this fact adversely affecting our entitlement to fundamental rights or personhood. Though animals possess higher capacities, there still exist some traits that appear to be unique to humans, but as will be demonstrated later, even if some general fundamental difference exists between humans and animals at the species level, it is not pertinent to the question of holding personhood or fundamental rights, though it may be relevant to determining their content and strength. Secondly, it remains true that animals are not currently, nor can reasonably ever be expected to be, moral agents or legal duty bearers. This is assuming legal duty bearing requires understanding, or at least the capacity for understanding of the duty. They thus cannot be bound by human laws in the way that most, although not all, humans are. However, neither moral agency nor legal duty bearing form the appropriate basis for assessing competence for personhood and fundamental rights. Because, as explained above, moral patients do not need to be moral agents, rights holders do not need to be duty bearers, because obligations are a function of capacities rather than of rights holdership. And even disregarding individual differences, these capacities are not universal among humans. There are various instances of personhood and fundamental rights being recognized and protected without duties being imposed. A strong example of this is the situation of uncontacted peoples who operate outside the jurisdiction of any recognized nation state and thus also outside the jurisdiction of international law. So they are largely exempt from legal duties while still being entitled to recognition and protection of their legal personhood and fundamental rights. Thus, even from a species perspective, humans are not universally suited for fundamental rights and personhood to the detriment of all non-humans on the basis of moral agency or legal duty bearing. We have the 2018 American case Non-Human Rights Project on behalf of Tommy and Kiko against Presti, in which Judge Faggy, in his concurring opinion, made the following clarification. Even if it is correct, however, that non-human animals cannot bear duties, the same is true of human infants or comatose human adults. Yet no one would suppose that it is improper to seek a writ of habeas corpus on behalf of one's infant child, see people extra vele against Weissenbach, or a parent suffering from dementia, see, for example, matter of Bravorka extra Whittle against Shoes. In short, being a moral agent who can freely choose to act as morality requires is not a necessary condition of being a moral patient who can be wronged and may have the right to redress wrongs. See generally Tom Reagan, The Case for Animal Rights. This concurring opinion was a pointed one. While it is technically a concurring opinion, to me, for the most part, it read more like a dissenting one. The case at hand concerned granting the writ of habeas corpus to the captive chimpanzees Tommy and Kiko. The court refused to grant the writ, holding that only a human could be a person entitled to such. Judge Fahey issued a separate decision, sympathizing with Tommy and Kiko and the NHRP's cause and expressing his personal struggle with the court's decision on the matter. A similar line of reasoning can be found in just Luis Armando Tolosa Villabono's decision in the 2017 case of Del Oso de Anteos de Nombre Chucho. We must reconsider what a holder of rights is. We must relax the principle that holds that such a thing is reciprocally bound to comply with a set of duties. And we must accept from now on that non-human sentient subjects are subjects of rights despite not being reciprocally constrained by duties. This case concerned the status of the spectacled bear Chucho in relation to his freedom. The Supreme Court of Justice granted the bear his freedom, holding him to be a rights-holding person and ordering his relocation to a more suitable environment. Rationale for legal personhood and fundamental rights. Sentience as a basis of likeness. Through the preceding analysis, human exceptionalism failed as a convincing basis for gauging likeness. Therefore, the rationale for fundamental rights and personhood must be examined to find the sufficient condition for competence to hold fundamental rights and personhood, and in turn, the relevant trait to form the basis of assessing likeness of non-humans by humans. This position can be discerned primarily from the writings of legal scholars and jurists, especially since other existing sources of fundamental rights law are largely silent on the matter. They simply assert that human rights are granted and human personhood is recognized by virtue of being human. Fundamental legal rights. Between the two competing theories that exist to describe the function of rights, the interest theory of rights is preferable to the will theory. The will theory seems ill-suited for the starting premise that all humans have fundamental rights, because under the will theory, marginal cases of humans are most likely excluded from rights holdership. But since we have seen that human rights are universal, inalienable, and equal, we cannot exclude marginal cases from fundamental rights. Thus, reliance is placed on the interest theory for discerning the rationale for fundamental rights. Drawing on Matthew Kramer's exposition of the interest theory, the purpose of rights, including fundamental rights, is to protect the interests of rights holders. This position presupposes that the holders have inherent interests to protect. By inherent, I mean as ends in that matter in and of themselves, rather than as means to some other ends. And that they have the capacity, even if it is merely theoretical or hypothetical, to suffer disadvantage and to enjoy and exercise rights. In other words, they must possess interests and sentience, with the latter generating the former. The inclusion of a merely theoretical or hypothetical capacity would cover non-sentient members of an otherwise sentient species, regardless of whether they actually have the potential to develop sentience or actualize their resultant fundamental rights. The relevant trait for competence to hold fundamental rights, and thus also for assessing likeness by humans, is sentience. Sentience is both necessary and sufficient to generate interests and thus generate fundamental rights. The existence of animal sentience and of animal interests is are recognized facts in the scientific community and in most legal systems, domestic and multinational. Sentient animals thus possess the necessary competence to hold fundamental rights and are like humans in the relevant sense. Applying Dworkin's interpretivism, if humans are fundamental rights holders, then so are like non-humans, including sentient animals. Legal personhood. Visa-Kurki's bundle theory of legal personhood provides a comprehensive account of legal personhood, free from the many problems associated with what Kurki terms the orthodox view. Notably, that the latter equates legal personhood with legal rights holding, legal duty bearing, or the capacity for such. According to the bundle theory, legal personhood requires either an agent or a passive rights holder, for example, an animal, and that the agent or right holder holds an essential number of certain Hofheldian positions, for example, claim rights. Legal personhood, so conceptualized, has both active and passive incidents, and while most adult humans possess both, even ones with undeveloped or diminished capacities possess at least the latter. Under the bundle theory, animals endowed with claim rights that comprise sufficient legal incidents conceptually possess passive legal personhood. Sentient animals possess claim rights because, as a result of the interest generated by their sentience, duties are borne towards them and not merely in relation to them. They thus have at least passive incidents and so are at least passive legal persons. Similarly, under the orthodox view, animals who have fundamental interests that deserve legal protection are persons. Sentient animals have fundamental interests and thus possess legal personhood per the dominant orthodox theories of personhood. Sentience thus appears to also be a necessary and sufficient condition for competence for legal personhood, under both the bundle theory and the orthodox view. Thus, under these views, sentience is also the basis for assessing likeness by humans regarding the competence to hold legal personhood. As before, sentient animals are like humans in the relevant sense, so applying Dworkin's interpretivism, if humans are persons, so are like non-humans, including sentient animals. Through this analysis, it has become clear that sentient animals are like humans in the relevant sense. They have the competence to hold fundamental rights and personhood as a result of the trait of their sentience, and thus cannot be denied fundamental rights or personhood under the foundational principles of fundamental rights law, properly understood. Though the content, strength, and limits of these fundamental rights and personhood may differ from one person to another, the possession of sentience generates interests and thus creates an entitlement to some form of fundamental rights and personhood. In other words, sentience is sufficient to generate both, but may not be sufficient to generate some specific form of fundamental rights. For example, the right to a fair trial or the right to vote would not be contingent on sentience alone. Ignoring likeness through speciesism. Arguments from human supremacism. Having rejected human exceptionalism, that is, the possession of exceptional capacities, and having found that the rationale for competence to hold fundamental rights and personhood is sentience, the plausibility of relying on arguments from human supremacism, that is, the possession of a supreme status simply by virtue of being human in the form of speciesism, will now be addressed. Without relevant differences in competence as a distinguishing factor, the only plausible basis for denying animals personhood and fundamental rights is speciesism. Peter Singer describes speciesism as a prejudice or attitude of bias toward the interests of one's own species and against those of members of another species. This entails notions of indefensible discrimination based on ideas of supremacism of the species. Using a difference in species to disregard the fundamental rights and personhood of all members of outgroups is not principally different from using differences in other inherent irrelevant characteristics such as race or sex to do so. It is thus not principally different from other supremacist notions and discriminatory practices such as racism or sexism. Discrimination on the basis of race and sex is prohibited under the foundational principles of fundamental rights law. We get this from various international and regional instruments on human rights. By analogy with these notions, supremacism, speciesism is conceptually incompatible with the foundational principles of fundamental rights law, of the rule of law, and of justice. Speciesism can therefore not be used to ignore likeness of animals vis-a-vis humans, and so cannot justify the existing legal status of animals. Thus, the justification for supremacism and thus speciesism does not fit the standing features of fundamental rights law, meaning that fundamental rights law cannot be interpreted in a way that allows for such notions. Also from the Chucho case, we have the following quotes by Judge Luis Armando Tolosa Villabona. Human beings are animals that give birth, are born, breathe, and die. This is a natural reality. Therefore, the new analysis of human rationality, self-consciousness, and development must start from our not ignoring that we are living animal beings. Consequently, if we want to survive, present circumstances compel us to point out that human beings are not the sole holders of rights, since legal entities, in virtue of a legal fiction, are also holders of rights. Hence, other sentient beings, including nature itself, can authoritatively claim such a condition, in virtue of their possessing it due to their very essence. If fictitious legal entities are subjects of rights, for what reason should those who are alive or are sentient beings not be so? So what precludes us from acknowledging the other truly living, sentient, animated realities with the judicial personhood, going beyond the traditional conception of nature as an object that humans have a duty to preserve? Since non-human animals are sentient beings capable of suffering, they must be the holders of rights, and the law protects them. Therefore, non-human animals are entitled to freedom to live a natural life, to prosper with the least possible pain, and to live a life with the standards that suit their status and condition, but essentially in a responsibly preserved habitat in the biotic chain. So, in conclusion, animals are fundamental rights holding persons, and by denying them this recognition and protection, we are violating the foundational principles on which fundamental rights law is based. Thank you.
Very much, Ankita. We are going to go to questions. I'm going to take questions from the floor first of all, because we want to make sure that the sound is good, and then we'll be able to take questions online as well. So we want to make sure everybody online can hear the questions in the room. So may I encourage you and invite you to ask questions? Yes.
Thank you for the presentation. I haven't studied animal law, so I hope I grasp what you just taught us. Now, my question is that does the recognition of personhood give the best result that we want for animal welfare? Because since personhood can only encompass so much of the animals in the wild, and that with personhood, seemingly the treatment is still subpar. It's like even if we recognize personhood, we are not giving the same treatment as human being. So I wonder if this is a worthwhile pursuit for animal welfare.
Right. Thank you for your question. So let's start with this. I argue that changing the status of animals requires two fundamental shifts. One is recognizing them as legal persons, and the other is recognizing and protecting both recognizing and protecting them as legal persons and recognizing and protecting their fundamental legal rights. So when we look at personhood, the impact of recognizing animals as legal persons, the greatest impact would be that they could no longer be treated as property. And when they can be treated as property, they can be owned, they can be traded in, they can be bought, they can be sold, they can be subjugated the way that they are being subjugated. Of course, it's possible to recognize them as persons and to still be able to hunt them, for example, because there is no ownership relationship in that scenario. But that's where the recognition of fundamental animal rights comes in, because once we recognize those fundamental rights, like the right to life, to liberty, it would also no longer be permissible to hunt them in the wild. So with these two things, my argument is that we would have robust enough protections to change the status of animals. And I would argue that this would be on par with the status of human beings. Right.
Thank you for your presentation. I have done a few readings on this, but I'm still new to the subject, and your extensive research has really helped me understand quite many perspectives here. My question is regarding understanding the scope of your argument. The basic argument of fundamental rights for animals. I'm trying to understand the scope here, and I would like to quote your presentation that you said that treating non-humans, treating like non-humans alike. This is probably what you said when you were laying the ground with scope. I would want to understand, you were comparing non-humans. As in, the argument was that you were advocating treating non-humans alike. So I would want to understand more on this. The scope of what else non-humans are we talking about?
So the argument I was making is we should treat non-humans like we treat humans. And the scope of that is the way we currently treat non-humans is obviously different from the way we treat human beings. And the argument I make is they are actually alike because they are also sentient. And on the basis of that sentient, we should treat them the way that we treat human beings.
The scope is animal.
Yes, yes. Well, non-humans can potentially also include things like artificial intelligences and whatever, but I focus on non-human animals.
That just clarifies all the things. Yeah, thank you.
There's one down there, and then there's one here, and then there's one.
I have two questions, but actually both which follow from points made already. My first question is, if one is saying that human exceptionalism is wrong, we should be treating like for like. Therefore, if you have a situation where a cat has rights and a mouse has rights, are we suggesting that that should not have anything to do with, can't torture and kill the mouse? If we are, then that's fine. But if we're not, are we having human exceptionalism as well? Because we're saying the mice has rights visited as humans, but not in relation to cats, in which case the rights are only attributed between humans and animals and not between animals themselves, in which case that must be human exceptionalism. And the second point was, if we're going to have given them human rights.
Do you think we could take it one at a time?
Yes, of course. I just follow two questions. Go ahead.
All right, thank you. So the first point, let's see. A cat's right to, a mouse's right to not be tortured or killed by the cat. Yes, a mouse would have such a right, but we cannot hold the cat responsible for torturing or killing a mouse because a cat has no understanding of what a cat does. So the point I made earlier about them not being moral agents or legal duty bearers would apply here. So the mouse has a right, the cat has violated the right, but unlike if a human were to violate the right, we cannot hold the cat accountable for that violation.
How isn't that human exceptionalism?
So humans, the concession I made to human exceptionalism was to say that animals cannot be legal duty bearers. So it was one of the two concessions that I made.
My second question is, do you really want human rights? I mean, to give an example, compulsory labour is allowed for civic obligations. What would stop, say, for instance, a horse being said that its civic obligations is to pull a plough?
Sorry, could you repeat that?
Well, under the European Convention of Human Rights, one of the exceptions to compulsory labour is undertaking civic obligations. There's imprisonment and compulsory labour.
Right.
But civic obligations is obviously a matter of interpretation. So what's stopping somebody, when deciding these matters, deciding that a horse pulling a plough is a civic obligation on the horse?
Because civic obligations typically arise, so in the case of incarceration, they arise because
No, civic obligations is not incarceration. It's like when you have to do things like everyone has to do a certain amount of
so civic duties, basically, like we have rights and we have duties that go hand in hand with those rights. And animals have rights, but they don't have corresponding duties because they cannot be duty bearers in the first place.
Because obligation is not a duty. They're not the same thing.
And what is the difference between an obligation and a duty?
Well, an obligation is a duty is something where you can you have to make a decision to do it. You have an obligation without actually having to make a decision you have to do it.
Right, I'm not aware of that distinction, but if we take that distinction, let's go with that. They're not duty bearers, they're also not obligation bearers. So they wouldn't have the duty or the obligation to perform labor, for example, because they cannot be held to the same standards that humans are held to, as one of the two exceptions to human exceptionalism.
We had a question there, and then I think there was one around here, and then
yeah, this is from online from Annan. Said, I like that you addressed the marginal cases point, but what do you think of the name the trait argument? Is that effective as an animal rights promoter, or can it be rebutted?
Which argument, sorry?
So you said you addressed the marginal cases point, but what do you think of the name the trait argument?
Name the trait argument. Could we have an explanation of what that is? Because I'm not familiar with it.
Yeah, it's effectively, the argument is that when you're trying to justify treatment of animals, you say, okay, name the trait that specifically allows you to do that to animals, but not humans. So say, for instance, it's something like, oh, it's a capacity argument or an intelligence argument, or a rights only come with responsibilities. So the idea is you say, okay, name the trait that justifies the differential treatment. I mean, it's a sort of a reworking of the marginal cases argument, but slightly subtly different. And it's one that's cropping up a lot in sort of vegan related arguments, for instance. And it's whether or not it works. That's my question. And you obviously know a lot about this. I'd be very interested to hear your thoughts.
So whether the name the trait argument works, which is the argument that you identify a particular trait that allows you to exploit animals in a particular way.
Yeah, I mean, I used to put it forward as give one justification for our treatment of animals that cannot be, and indeed hasn't been, used to justify the treatment of at least some humans. But the name the trait seems to be a sort of better way of arguing it.
So is this how do you mean does it work? So do we find?
Well, I'm just curious as to whether you think it is a useful argument, or whether I mean, to me, it seems that it does work, but I know there are people who say, well, actually, I'm not sure that is a good argument. And I'd just be very curious, because you've got the background knowledge and the expertise of the wider issues, to just say, I'd be very interested in your opinion as to whether you do think it's an effective argument or not.
So if I've understood correctly, I think it is an effective argument. If it's like the argument for marginal cases, we have that is often, so all the justifications that are put in place to try to justify away our treatment of animals. Often these arguments would apply equally to humans, but that is something that people fail to consider in the majority of cases. And if the name the trait argument is similar to it, then yes, I think it is a very strong argument.
Oh no, thank you. That's useful to know, because a lot of the time the argument just boils down to a sort of an arbitrary distinction that, oh well, they're animals, so it's a different thing. But of course, one of the oldest arguments for treating humans badly is just categorizing them as somehow not falling with, because it's a very common prelude to sort of human-related atrocities to start to, quotes, dehumanize people by comparing them to animals.
Yes, definitely. And that has historically been done. It's also been used as a justification for perpetuating all types of atrocities on groups of human beings. because they've been dehumanized, and then that dehumanization then somehow allegedly allows us to treat them badly the way we treat animals.
Yeah.
But of course, my argument is we can't treat human beings badly and we can't treat animals badly because the foundational principles of fundamental rights law preclude us from using these differences and capacities to mistreat persons, be them humans or animals.
Yeah, because that's my point, that even if you don't care about the animal side, if you just care about the human side, a lot of, we condition children pretty much from birth to accept certain, certain premises, such as, some, cruelty is acceptable and necessary, that, the powerful and the strong have a right to dominate the sort of weak and powerless and things. And I think you can flip it on its head and say, well, actually, the animal rights argument bolsters the human rights argument.
Yes, absolutely.
Oh, thank you.
Thank you.
We have some more questions online.
Yeah, we've got more online, so I don't know if Kim wants to turn their microphone on. This question.
Yes, thank you. Thank you for the presentation. My question is simple in the way I frame it, in that this is aspirational as to what we would like to see be in reality, but how do we make it a reality?
So that is addressed in the subsequent chapters of my PhD, which I am still writing. But
can we have some insights today?
Just an overview then. I think that this is only possible if we, as Ann Peters has suggested, do it at a global level. So the international level, the regional level, as well as the domestic level, we need what we need. And this would prevent, for example, the outsourcing of animal rights abuses. So the strongest example is a country, say the EU has banned cosmetic testing of animals. And what it's effectively done is a lot of these companies have taken their cosmetic testing to other countries that allow it, and they've continued with their cosmetic testing, just in a different geographical location. So the first argument I make, borrowing Ann Peters's work on this, is it has to be done at a global level. We need it. We need a multi-level approach so that the laws complement each other and together create this really strong net that is inescapable. So we don't have pockets of geography where animal rights violations can take place unchecked. So that is the strategy. And another point I have on that is the recognition of animal rights should follow the trajectory taken by the recognition of human rights at the international level. So there were domestic human rights movements as well, but at the international level, it took sort of a bottoms-up approach. It tried to incorporate a lot of domestic and regional developments and coming up with something that is truly universal. And of course, human rights still gets criticized as being anglicized or being westernized and not reflecting indigenous values as much as it should. But from the looks of the Universal Declaration of Human Rights and the international covenants, it seems that they have tried quite, and I would argue have actually succeeded to a great extent at producing something truly universal that can apply to all human beings, regardless of where they are. So a similar trajectory should be followed by animal rights protections. And those are two of the key ideas I'm working on now. More to follow.
Okay, thank you very much.
And what's interesting about the cosmetics testing is, of course, it's not just about where the testing happens, but the impact of the market. So of course you can't import products that are that have undertaken testing. The real issue with regulating cosmetic testing is its interaction with the REACH framework. But and so that's quite interesting, I think, for your perspective, because it's a conflict between the human welfare and the animal welfare, and then exceptions that are about the humans that might be exposed to working with certain chemicals. So it's in that case not outsourcing, it's actually about the conflict between human and animal interests in that specific context. So it's an interesting example. Is there another question? Okay, yeah, I'll start with Ashpil.
Thank you so much for your presentation. I would like to know, according to your research, which national law is closer to recognize animal rights as fundamental rights in current situation? Would you think like?
I would say Indian laws, because they've had about 20 cases talking about fundamental animal rights, and something like the Nagaraja case, I think 2014, actually declared all animals to be fundamental rights holders. So in theory, I would say India has a lot of jurisprudence on this. They've interpreted constitutional provisions in a pro-animal way. They've extracted the animal right to life from the human right to life. The duty of compassion on Indian citizens has been treated as kind of creating rights for animals. They've done a lot in that respect, but I don't see it actually translating into practice. But I don't see it translating into practice anywhere in the world. But if you're looking in theory, I would say India is pretty advanced in that regard.
Do you think the regulations are effective on that, or just is it based on human approach? I don't know.
So in theory, they're not anthropocentric. Some of them are, but a lot of them are not. But I don't think they're effective because I'm yet to see the practical implications of these judgments. They make sweeping declarations in favor of animal rights, but we still see massive, large-scale animal abuses in India, as we do in almost all parts of the world. So it has yet to translate into practice.
Thank you. I'll take Clinton because I know I accidentally forgot that you.
No worries, and thank you for your presentation. This is just to sort of pick your brain and hear your thoughts, because a common argument often made, especially in potentially developing countries, is we struggle to sort of uphold even human rights. How could we possibly think of bringing in an animal rights framework when we're already sort of struggling with what we have? I was just curious on your thoughts on that type of argument.
2 points on that. First is that it's a very anthropocentric argument. It assumes that human rights are more important than animal rights. And I think one of the reasons for that is humans have a voice. So if you oppress them, they actually can scream out in pain, or and animals don't actually have a voice that we understand. So that's one of the reasons I think the lack of speech by animals is one of the reasons we treat human rights as mattering more. But it is an anthropocentric argument, and I don't think that animal rights are necessarily secondary to human rights, or that they should be subjugated to human rights. And the other is that the recognition of human rights and animal rights has been shown in studies and a lot of literature to actually go hand in hand. So there are developments in, say, psychology that state that those who mistreat animals have a higher propensity to mistreat human beings. We've got either the dark triad or the McDonaldian triad, I can't remember which, but zoosadism is one of the traits of psychopathy or sociopathy, depending on which triad it is, but I can't remember right now. So we see that treating humans and animals fairly are things that are not necessarily in conflict with each other, but something that goes hand in hand.
I'm going to take one online, because we've got quite a lot online.
Yeah,
And I'll
so
come
I
back to
took one from Maureen. I don't know if Maureen wants to turn off the microphone. Mark, just read it. They've said, thank you for this presentation and for referring to decisions taken by different courts at the domestic level concerning the legal personality and rights of certain non-human animals so far. At the international level, how could this be done on the legal front? Would it ever be conceivable to acknowledge by way of a treaty that other animals are legal persons with fundamental rights, considering that an international court could hardly do so, it seems to me?
So at the international level, I think it would require the consensus of the national players that form part of the multinational organization. I don't think it's something that any international court has the power to decide unilaterally. We see amendments to national instruments national instruments, we see the Constitution of Basel status. There are talks of amending it to include the personhood, I think, of great apes. At the international level, we see the TFEU in Article 13 recognizes animals as sentient beings. I don't think it is a far cry to say that we might someday have an instrument that actually recognizes animals as persons and purports to recognize their rights. But I do think it's going to take a long time, and I think it will happen incrementally and gradually and slowly. But I do believe we will eventually get there, like we got there for human beings. From the Universal Declaration of Human Rights in 1945 until now, we're still coming up with new instruments to protect new classes of people. So it is still an ongoing process. And it's not very old, but it's gradually growing. And I think the pace will be slower for animals because of one of the questions I had. What one of the questions mentioned is that we are anthropocentric in our views, and we do tend to prioritize human rights over animal rights. But I do think we'll get there just in time.
I think we should take another one online because we have quite a lot online.
Yes, we've got another one from Kelly Logan on their microphone. So Kelly's written, should there be a human face of animals that represents the interests of animals as a legal rights holder? Perhaps something similar to the legal setup of the Whanganui River in New Zealand, where the river is a legal entity and exercises its rights through a human agent or trustee.
Absolutely, there absolutely should, and there needs to be, because if we give animals or they recognize these rights and this personhood of animals, animals still ultimately lack the ability to represent themselves before courts to seek redress when their rights are violated. So we definitely, absolutely need a human face, someone to represent them, someone to stand up for their interests. And we have NGOs all over the world that try to seek this already. So stronger stronger actions and stronger, more powerful organizations, maybe we take NGOs, some of the strongest ones together, and we might have enough to represent animal interests.
There's a quick follow-up, isn't it?
If we have a human representative, what happens if, going back to my cat and mouse example, but using a different example, you have a lion and antelope. The lion has a need to eat and has a fundamental right to eat. The antelope has a fundamental right to live. You have a side person representing each side. Who should win?
Right, so I actually addressed this in one of my chapters, and this comes under what I term as derogations from the basic position that we have these rights that are inviolable. So in situations where you need to kill in order to survive, I treat that as an excusable derogation from the position that you cannot violate another's rights. And that also applies to human beings. So if a human being needs to kill, say, a fish in order to feed themselves, in order to survive, then that would be a permissible thing to do. It would still be a violation, and it might not be justifiable, but it would be an excusable derogation.
And so a cat, well, unless, assuming they're not a feral cat. Actually, feral cats might be interesting, but a cat wouldn't be comparable to that with the mouse, because cat, what should be getting our food, or how do we? So
the cat's right.
Do you put that responsibility then on the owner of the cat? Because I was just thinking of the cat and mouse example.
How do you remedy the cat and mouse example? I mean, if you have the cat and mouse before, somebody's speaking for the mouse, somebody's speaking for the cat will probably lose, because for the reasons you said, mouse, if it's just they're inflicting torture for fun, that's not going to derogate food, whereas the mouse has a right to life. So how would a court implement that? What would it do?
So it comes back down to this point I made earlier, that animals cannot be held accountable for their actions, because as far as we're
aware, you have a duty to the mouse. Imagine it's in somebody's house. Do you have a duty to keep the mouse alive in your house? If you leave the cat to kill it, are you saying the cat doesn't have duties, so we don't have duties towards the cat because we're not responsible for the cat?
Are you using the cat as a tool to kill the mouse? Because then you're a principal.
A cat who likes to kill mice.
Because, well, you could be an accessory, secondary liability, even if.
Wouldn't be. That's giving agency to the cat.
But is that why you need a kind of property framework?
Well, again, you have a property.
Because I mean, it's that kind of guardianship through the ownership of the cat. Is that
because somebody else could be the cat?
But you can have secondary liability in the absence of primary liability, even if.
Sorry? There's certain sexual offences you cannot be possible to be a primary because of the nature of the offence, but you can.
So there are exceptions, yes. You could, in this
Well,
case,
you're not though. You can't. You don't know the mouse is in the house. You just know the cat is in the house.
then you're fine.
But the cat. What about how do you remedy it for the mouse?
Put enrichment for your cats and don't let them out.
Do you have to contain the cat? And at which point, if you have to contain the cat, how do you then protect the cat's rights to being detained?
So you detain the cat in order to prevent the cat from eating the mouse? Is that the question?
Well, I mean, that will be one way of protecting the mouse, but then the cat loses some rights. So I'm just wondering if the cat therefore has a right to speak to protect.
Can I jump in?
Okay. This table's
I
getting
remember
round.
something from, we are familiar with Martin Nussbaum has an argument with this issue. So when you say cat or lion has a right to eat, sort of she taxonomizes that action. The first is that lion chases the antelope, that is itself an action, that's the nature of the lion, and then there's the nutrition aspect of it. So if you are in wildlife, that's different. It's not human supervision, but if you are supervising the environment, you can sort of provide lion both activities and protect antelope at the same time. You can sort of give the lion the physical activity of that action in different ways while feeding him or her or it in a way that doesn't harm the other animals. So that's, I think, a practical answer, not the legal liability, but just reminded me of that issue.
Or another situation we can take as a child who likes, a really small child who likes eating mice. So would the parents be forced to contain the child? It's obviously a question of balancing competing rights. And I don't know what would happen in each case of balancing because.
The right to life, one would think is the highest right.
Sorry?
The right to life is the highest. So one would think if you're having a hierarchy of life rights, the right to life would probably be, if not at the top, close to the top.
Well, when I discuss the strength of rights, I also take into account the capacities of the rights holders. So there would be situations where the right to life, and an easy example of something that could trump the right to life is the right against torture. So I don't make kind of absolutes in my work at all. And
euthanizing animals, for example. Euthanizing animals, for example. If there's great suffering,
that would be
euthanizing would be the right. You're saying that might be an example where torture would and them to suffer over.
Keeping them alive would be torture, do you mean?
Yeah.
Yeah, so euthanizing an animal would be an acceptable thing to do, just like euthanizing human beings, I would hold as an acceptable thing to do, especially if the human being is capable of kind of consenting to it, then.
So we don't know the animal.
Yeah, and it's harder.
Yeah, let's take another question from online and then Priyal. Sorry, Priyal.
Joy, I don't know if John wants to turn their mic on. No. So they've written, while it is no doubt desirable to eventually confer personhood on animals, it may be some time before domestic law actually accepts or recognises that legal position. What, in your opinion, can national courts presently do to interpret laws that are premised on speciesism and subordination of animal rights to human rights, reading an animal rights into fundamental rights guaranteed to humans under the Constitution is one option, but are there any other methods?
So it would, of course, depend on whether it's a common law or civil law jurisdiction. Common law judges have far greater authority to interpret laws in accordance with how they believe it should be interpreted. So if it is within the common law jurisdiction, I think the way forward is for courts to try to interpret laws in pro-animal ways as to the extent that it's possible. Of course, there are issues of legitimacy that might crop up if a court were to stray too far from, say, a legislation they were interpreting. And if it is common law, then it is up to courts, depending on their kind of hierarchical position, to change the common law. So yes, so that.
I'm conscious that you might be starting to feel quite exhausted. So how many questions do we have left online?
It's more just points.
Yeah, okay, because what we're going to do is we're going to open it up into a sort of more general roundtable discussion, even though we have no table. It's a very you've got to imagine the table. This is our version of the metaverse, is not having a table. But if there are some specific questions about Priel's presentation, or if you prefer to open it up to discussion so that everybody can kind of jump in as well. Any specific questions? Priel, so did I say Priel could jump in? Sorry, Priel. I mean Ankita, sorry. I'm trying to remember who's in the queue. So yeah, so we'll take Priel's question and then we can have a look at a couple online and then open it up.
Thank you for the presentation. I have one question, and I just want to know a general view, like your view on that, because it's been ringing in my head for like a really long time now. So my question is specifically in relation to Russia. A law was passed called the Law on Responsible Treatment of Animals, signed by Vladimir Putin, which prohibits the killing of animals under any pretext. Now, Russia gets most of its monetization and commercialization through the tourism, and in furtherance of the tourism, it's the kind of clothing that people buy, wherein they kill a lot of birds to make snoods and caps and coats, which is made of real feather. Now, that kind of clothing helps people survive the winter there. So there's a right to life in terms of people. And then there's the aspect of commercialization and monetization of the GDP of Russia. And then there's animal rights. Now, in this regard, how do you define the strength of rights? How do you balance it?
So the first question I would ask in this situation is, what if instead of animals, they were killing human beings in furtherance of their livelihood or whatever? Would we think it's an acceptable thing to do? And I don't argue in my thesis that it's equivalent harm to kill a human versus killing an animal, but it just kind of sets the stage for what kind of alternatives we can come up with. This would be the right to livelihood. I distinguish it from the right to life proper. And for the right to livelihood, the argument that I consistently make is find an alternative, find some other way of sustaining yourself. And in most cases, that is possible.
Basically, that argument covers the commercialization and the survival aspect.
Did I miss one?
Okay. And it's interesting in relation to clothing, because of course this is one of the areas where also IP comes into this, is that how you also use that innovation and research environment to encourage investment and development of alternatives. So alternative proteins, alternative fabrics and textiles. There's actually there's a whole other interesting dimension of that interaction between IP and animals in that context. So it's a good question. Maybe we take a couple more online and then we'll open it up. Unless there's anything specific about them.
Comments. So Barbara said, just to share with you, a couple of days ago, the Italian Parliament passed a law to better protect animals by mentioning them in the Constitution. So hopefully that will turn into good practice. Okay, just to comment, it might help with your PhD. In the Philippines, we have a case decided in 2018 which ruled that while dolphins and other sea mammals have no legal personality to sue, citizens can sue on their behalf. Lux has said, when you mention the outsourcing of animal testing to other countries with laws that allow it, I see a strong connection with this and, for example, industries that cause pollution. So when countries create laws or regulations about it, they just take it somewhere else. I was wondering if you have dived into the subject of environmentalism as the context of non-human animal rights.
No, not really.
So that,
I mean, and anyone who also wants to jump in, if you've got any points on any of these questions. They're quite, oh, yeah.
If anyone else want to go first, it's all right. But I have a sort of maybe a pragmatical approach to it, but the sort of expanding fundamental rights to sentience, to me, it's like rooted on the natural law versus positivism debates, how you define the right holder, how you define the fundamental rights. But that's why I call it pragmatic in the approach that how do we enforce it, how do we make it the sort of reality and practice of law. I'm wondering if there are any other legal activism beside the case law, because we see in you give the examples from India, from US, we have one in the Argentina and in Philippines from the case law comments. So the case law sort of is a common method to sort of make this enforced or expand the right holder to sentient beings. But I'm a bit curious about, are there any other ways to within the legal world, within legality, to sort of push this issue forward?
At the domestic level, there can be amendments to legislations and constitutions, like the example I mentioned in Baselstadt. There can be extraterritorial application of domestic laws through principles like protective, objective, subjective territoriality, all of those. Then at the international level, and this is something I'm really strongly hoping for, there can be a declaration on animal rights. So there was one at the UNESCO headquarters by an NGO not that long ago, but I think the protections in it were fairly minimal. So a strong declaration in favor of animal rights at the international level, states could come together in their various regional and international organizations and put forward binding legal instruments. So there are.
Yeah, but that's what I was meaning with being more practical with it, because if you go with the legislation, change in legislation or like international acts, then you are gonna deal with lobby from the huge industries that uses animals in many ways. You are gonna deal with cultural norms of hundreds of years that is changing with the social media, but that is still there out there. That's what I was meaning, but with this like rooted in positivism versus natural law, and maybe a bit more sort of critical legal studies approach to it, in acknowledging that this is not only a matter of definition in the right holder, but also fighting it out, sort of making people accept that definition. That's sort of my curiosity with the future of this field.
So we have gotten there, and there have been laws that have been amended in pro-animal ways. Most countries have welfare and anti-cruelty legislation, and most times that these were passed, there was a lot of opposition from lobbyists, like you mentioned. And we saw these in numerous countries at pretty much every juncture where animal protection laws were passed, but they were passed nonetheless. So if it goes a step further and actually goes to animal rights, we can expect a similar, perhaps stronger, definitely stronger reaction. But that isn't to say that we might not get there someday, because concepts like veganism are on the rise. People are becoming more aware of animal interests and are more sympathetic towards the cause, and it's spreading, and it might take a very, very long time. But I think the trend is in the direction of animal rights. It's just getting there.
I think it's interesting that you refer to that, because it also suggests the importance of, and also in Oljan's question, the importance of the wider legitimacy of these changes as perceived by the public. And that's sort of part of that implementation environment, as part of the enforcement environment. And that's why I think, and this isn't meant to be a segue, but that's why I think this kind of innovation in the curriculum is very crucial, because it means that it's not seen to be a fringe topic. It's not seen to be something that is an afterthought or a separate marginalized area, but it's actually part of how you interpret and perceive the law. And in its kind of most abstract way, perhaps, but something like the Sentience Bill, which we know is in the UK, which we know is sort of facing some resistance. In principle, that's an example of that sort of process, because it's about approaching the law with a kind of empathy and a sort of multi-species approach to legislative reform, and to see that emerge in that context. So legislation going forward, legislation going backwards, kind of thing. I think that's an interesting example, maybe of that's sort of like what you're saying, Oljan. I think if it worked, if it works, if it goes into force and actually works that way, then that's in itself quite a big thing. Yeah. So, so do we have more online? I think no more online. Any other questions in the room? been a great discussion. It's been loads of questions. Oh, I don't know if I should let you ask any more. Okay, go on.
This may be a sort of final point. If everything came to pass, would we cease to be a multi-species society?
What do you mean?
Well, at the moment we live with animals. But if they have liberty and we can't, and they have rights not to be captivated and held by us, would we cease to be a multi-species society? Become a society.
I think it would still exist in the wild, but eventually domestication of animals would become, well, we wouldn't be able to domesticate animals, so we would care for the animals we have at the moment, as Gary Francione has said, but we wouldn't bring more into existence.
Yeah, I have quite a controversial view, which I've owned. That's not meant to be at the time. It's actually the title of the book, but owned publicly. I was always going to say. But if you kind of look at domestication science, I think it's actually a form of anthropocentrism to say that we solely domesticated animals. And if you look at the history, so the dog is everyone accepts the dog was the first domesticated animal. But if you actually read through the science, and a lot of it is how we interpret the science and the kind of anthropocentric viewpoint on the science. So originally, oh yes, we domesticated the dogs. We wanted them to keep warm. Then they went, oh no, actually, dogs wandered in and they wanted to eat some food. And they also wanted to be warm. And then instead of looking at that as the dogs having any kind of agency or any kind of control over what they were doing or having a bright idea actually being invented, it's, oh, dogs were just scavengers, they were just opportunists. And so again, we're kind of interpreting them out of, and my view is that dogs domesticated people, because dogs moved in and dogs taught people how to they basically taught them a kind of pastoralism. And so my radical view is that, in fact, dogs taught us how to domesticate, but I know it's rad, but I think it's actually quite important, because you're kind of going from the science, you go and looking also at how we interpret the science. It also is filled with this sort of assumptions and presumptions that we go forward in the way that you've been talking about with human exceptionalism. I think you can see it. And so now, at the very least, there's a concession that there was a kind of a co-domestication, but there, I think that we imitated what the dogs showed us to do.
So in light of that, I will change my answer.
Chapter 1. So any other points? There's actually something interesting also about goats in that relationship too. But goats and ungulates and so forth were domesticated far later, but some people have been researching on the relationship between goats and humans and rethinking. But it's in the sort of Zoe archaeological records that this is starting to be apparent, and it's very, very interesting. I didn't mean to kill the room.
So do you think the idea of personhood is diminished when we think of animals as creatures which are led by instincts?
No.
Oh no, not at all, because personhood encompasses human beings, and we have varying levels of kind of, let's see, cognitive involvement in what we do, without saying that including, for example, marginal cases of human beings, calling them persons doesn't necessarily diminish my personhood as a non-marginal case of a human being. So I don't think encompassing others would diminish existing notions of personhood. I think it would just make it more complete.
I think it's also a little bit like the domestication example as well, because if you reduce non-human animals to this idea that they're led entirely by instinct, which is also refuted. Oh, no. Yeah.
They're led by instinct, it's supposing that we think on that side. So
that kind of, yeah, no, exactly. And that sort of biological functionalism that's applied. And yet, if you then kind of take an interdisciplinary approach and you look at cognitive ethology and so forth, you see that too is a kind of anthropocentric viewpoint on what is human, what is non-human. There's a question.
We have been discussing about the right to life of animals, and I think somehow domestication is also not harming them. I mean, I'm talking about pet dogs and cats. But I would want to know your stand on neutering the dogs and cats that usually people do. Do you think that's justified?
I think domestication does harm animals. So my stance on domestication is that we should stop bringing more animals within that realm. Of course, excluding the animals who've self-domesticated. And when it comes to neutering, I think that they have, so this is kind of a conflict of rights that are relevant to the individual dog. So it's not a human's right versus a dog's right, but it's a dog's right versus a dog's interest. And I think, like I've said, I tend to avoid taking kind of hard stances on this because every time I think about it, a new perspective pops into my head. So I'm going to refrain from taking a stance on it once again, but except so far as to say the rights need to be balanced, the interests need to be balanced. And in this case, two of the individuals' interests are conflict with each other. One is, of course, the interest in being able to procreate, and the other is the well-being or the welfare of the dog.
It's always important to learn at law school that you will always have to know how to say as an answer, it depends. Any other questions? I mean, we have some light refreshments in the room, and I'm very sorry that that doesn't include the people online, but do we have any more questions online? Nothing online? Well, if there are no more questions, I just want to thank Ankita very much. That was a wonderful presentation and also fielding so many questions. We've obviously demonstrated a really rich environment for this kind of innovation in the curriculum and going forward with the future of animal law. And we're going to be planning more of these roundtables, so we will keep you posted. And also, if you want to keep up with animal law at Queen Mary, you can follow, if you're on Twitter, Animal Law Custom. Or me. And I will certainly make sure that you hear about 500 times if anything's happening, so you won't miss out. So thank you again, everybody. Thank you to the audience. Thank you to Christine for all the work setting this up, and thank you to Ankita.
Thank you so much. Thank you for having me. And thank you for being a great audience.